Good morning. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for May 15th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. We are also streaming all matters live via YouTube for public viewing. Mr. Nunez, would you call our first case, please?
Yes, ma'am. Calling cause number 2023 DCV 1852. 2023, Rafael Garcia versus Amerilink et al.
You have announcements, please.
Good morning, Your Honor. Oscar Lara here on behalf of Rafael Garcia.
Good morning.
Good morning, Judge. Adam Cetra here for Amerilink and Mr. Alberto Yoshimoto.
And good morning, Your Honor. Aldo Lopez on behalf of defendants Swift and Sneed.
Good morning, gentlemen. We're scheduled for a motion to compel. Bear with me. My system is just a little slow. Motion to compel and status conference. Amerilink, it's your motion, is that correct?
No, it's mine, Your Honor.
No, Your Honor. It is plaintiff's motion, and just want to. Are we on the record right now? Because
We are.
If not, I would request it. Okay, perfect.
Okay. Yes, Your Honor, it's my motion.
Go ahead, Mr. Lara.
Your Honor, it's a very basic, straightforward motion. On February 12th, we served Amerilink with discovery, request for production, and interrogatories. Mr. Cetra requested an extension, which I provided for up until March 29th of this year. And up until that point, that time period passed, and we still did not receive any responses to the discovery. Now, Mr. Cetra did provide me some documents, but without any formal discovery responses. And to be transparent, Mr. Cetra represented to me that he was going to be withdrawing from the case. But Your Honor, we don't have any formal discovery responses from Amerilink. We don't have any interrogatories. We don't have any response to requests for production, and we don't know if we have received all the requested documents. The time period has lapsed, and any objections that Amerilink may have asserted at this point, Your Honor, we request that they be deemed waived and all requests be honored, and they respond accordingly.
Okay. Mr. Cetra?
Yes, Your Honor. Mr. Lott is correct. I did have that discussion. However, with regard to withdrawal, that's while this is pending, that's not going to be at issue here. If there's a document that I've received, it's already been produced. If there's any documents that I do receive, I'm sending them over as they go. I'm having difficulty getting my client to respond. I would just ask if the court can issue an order with just a drop dead date. So I spoke with him this morning, let him know the importance of this, so we're not wasting anybody's time on this. And with regard to the objections, I understand. I think when the 30 days passed, I think that was understood. And
What was understood?
That objections are waived on discovery if it's so. To the extent that that's, how do I put it? That objections are waived doesn't mean that anything that's produced is automatically admissible anyway. So I will have a talk with my client once we get a date, if we can. The court will give us one, so that he can go ahead and
date for
get
what?
these responses done. Just a drop dead date, and if we can get an order, just defendant must produce documents or complete all discovery by this date, so that way I can put some fire underneath his feet a little bit to get him to go. He's an older guy. He's a little bit shaky, worried about this case, freaking out a little bit, to be honest with you. And I'm hoping that that'll spur some action here as well, so we can get them their responses.
All right, Mr. Lara, what are you asking from the court exactly? I understand. I mean, it doesn't sound like anything has been produced, right? There have been no responses to anything, right?
I
guess some documents, sorry.
Right, yes, I'd have to receive some documents, but Judge, we want complete responses. And with all due respect to Mr. Cetra's client, if this is stressing him out, he should be responding to discovery and taking this as seriously as he should. And I guess an order, I would say no later than this Monday, the 20th, Your Honor, to provide complete responses without objections, with all responsive documents. That's 5 days. I think that's fair. That gives them the weekend to do everything.
I'm gonna say that's very limited, Your Honor, and that 5 days.
When were
to-
they originally due? Back in March, is that right? Or was it February?
Yes, we served them on February 12th, so I'm offhand, Your Honor, March 13th.
Mhm. And there's been nothing, no, yeah.
Your Honor, there's been a back and forth. Documents have been produced. Mr. Lotta, there was a coverage issue early on that we had to discuss. I sent him response documents with regard to that as well. I can get at, I mean, I just would request just a reasonable amount of time so I can actually meet with him and get all these things as well, because I need him to verify his responses in person. And so
Has that not been attempted up until this point? I mean, I'm assuming that's what's been going on when you asked for an extension.
It was, Your Honor, it was, but I didn't receive complete responses from him first. And then secondly, he ran out of time and he had to leave. We did meet at my office. We went through as much as we could, but we're limited in time, and the discovery requests are extensive. There are quite a few. With regard to production of documents, I think that this is a small business. It's not a giant enterprise with retention, and they've got documents and storage and stuff like that. So I think he's digging through and trying to get anything he can, and everything he can. And like I said, everything I've received, I've put into a Dropbox folder for Mr. Lotta, and then we'll kind of itemize them and label them appropriately. But right now, we don't have everything at all that we need. And so I would like that opportunity for my client to be able to just finish this out. And I think it's clear now, especially from the conversation I had with him earlier today, that this is kind of the end of the line with getting these things over to me so I can produce them and comply with discovery.
Right. Anything else, Mr. Lotta?
I think the only thing, Your Honor, is that, I mean, it's been over 3 months since that they were served. I mean, I don't know why an extra 5 days would be such a hardship if he should be at this point doing everything possible to do so.
I'm going to grant plaintiff's motion to compel, yes, until Monday, Mr. Cetra, Monday noon.
Your Honor, I'm not in El Paso. I can't meet with him in person. I actually have dispositive motions in Hidalgo, so I don't think that we're talking about a reasonable timeline here.
I think when you consider please don't speak over me when you've had an extension and it seems to be the same excuse. I think 5 days is more than enough time. That is going to be the deadline. Mr. Lotta, please provide me an order today. We're going to reconvene in 1 week.
And Your Honor, with regard to I believe that there were some orders that were filed by the court. And so where I think the defendant was, I believe the court signed protective orders with regard to Mr. Yoshimoto taking any depositions, including not only of the plaintiff, but I think there was a protective order that he could not even take depositions of a third party. And so
what order are you talking about, Mr. Cetra?
There is I'm looking at the register of actions right now, and it looks like there were orders that were order granting on March 14th and another one order granting on the same day. The index numbers are 25 and 26. And I don't think we had a hearing on those. I don't see anything here indicating there was one. And so I'm just wondering if those are still in full effect, or if we need to file a motion to vacate those orders, because we're not able to take anybody's deposition due to those.
Motions to quash were filed back in February.
Correct, Your Honor. And I think the motions were just that they were noticed without conferring as to time and availability, and that's it. I mean, we're
Right.
more than happy to coordinate with dates and times with all parties, including Mr. Lopez for depositions.
Have you done that, Mr. Cetro?
We have, Your Honor. I have not been provided with additional dates. I believe Mr. Lopez, his office was also in agreement with the original date that the court, I guess the day before, signed the order granting these protective orders. And once again, it's against a third party that I don't even think the plaintiff had standing to quash, but either way, or to request a protective order. So my question is, do you want me to file a motion to vacate on those, Judge? Because I
No,
don't think we
sir.
were
No,
provided
sir. If
notice
you
on
had,
those.
Mr. Cetra, if you had a response to the motion to quash, you should have filed something. Did you file something?
No, Your Honor. There was no hearing set on those to trigger anything for responses. So I requested a hearing. I've requested a hearing several times.
For
and
what?
then just granted. So it's okay, Judge. I'll file it.
No. You're stating something on the record, Mr. Cetra, that you filed something, you're requesting a hearing, and I'm asking you for what? Because if you have requested a hearing and I have failed to comply with the request, I want to get to the bottom of it. So please tell me.
Yes,
When
Judge.
did you request a hearing?
I requested a hearing and I believe it was also on the record in March, I believe the March 6th status conference. There was a visiting judge who presided over that. I requested a hearing, and my understanding is that we needed to confer, and then would get back to the court because we would have a subsequent hearing the following week because the court would not take up the issues regarding the motions to quash that were filed at that time. And then following week, I believe just prior to these orders being granted, I believe I received an email from the court coordinator telling me that I needed to file something and that I think I had maybe half an hour to file a response. Otherwise, they were going to be granted.
Did you confer as per the instruction from the visiting judge regarding any issues with scheduling depositions?
We did, Your Honor, and then we submitted an email to the court coordinator indicating that the parties were unable to reach an agreement, and so that we wanted to proceed with the hearing. Then we were told that that time slot was no longer available, and then the protective orders and everything was granted that same Thursday.
Okay, so it sounds like folks are open to rescheduling those matters. I am not hearing that you all have come up with a date since March or February, whenever, I guess, end of February, when the motions were filed. Frankly, it looks to me like nothing is really moving. And so we don't have responses to discovery requests. We don't have agreements on deposition dates. Do we have a scheduling order? Let me go back.
Don't believe we do, Your Honor. With respect to Mr. Lopez's client, I can represent that, Mr. Lopez is working on his discovery responses, and we're working on once we get all those, we can work together on deposition dates. At least as of right now, I haven't had any issue with Mr. Lopez's clients.
And Judge, I don't believe there's a scheduling order. I think
There
that's
is not.
part of
Yeah.
what today's for, is to get a scheduling conference, I believe, is
Oh.
our second setting.
Right, we have a status conference. This has never been set for scheduling, so we're going to take today as a scheduling status conference. This case has been, let's see. Kind of scary to go a year out from today because that's May 2025, and frankly, I can't think of when I've scheduled anything so far out, but it is what it is. I'm going to give you a trial date. It's going to be May 2nd, 2025. Myrna, we need to get them a scheduling order.
Your Honor, is there any way
Monday.
I was going to say, is there any way we could do maybe a week later? Just Mr. Hernandez is lead counsel in this case, and I know he's on vacation at the end of April for his wedding anniversary.
Sure, we can do the 16th of May. Get us after
Okay.
Mother's Day.
Thank you, Your Honor.
To 16th of May, docket call is the 14th of May.
This is the Truth in District Court. I'm calling for Sarah.
Mr.
Lynn.
Nunez, would you please mute? So I am going to have you all have that scheduling order ready for our hearing next week. So next week, we're coming back on the motion to compel and entry of the scheduling order. Okay, we'll do that at the same time, Myrna. We won't do it at the 3 o'clock slot. I want to make sure if we have any hiccups that we're discussing those with everybody. Okay.
And Your Honor, if I submit the motions to vacate, which I think I've already got drafted, can we take those up as well at that hearing?
As soon as you have them filed, email Ms. Hernandez, request a hearing, and we can have it on that Wednesday as well.
Okay, fantastic. Thank you, Judge.
Alrighty. Anything else for today?
Nothing further, Your Honor.
We'll see you next week. Thank you very much.
Thank you.
Thank you, Judge.
All right. Who's next?
On page 1, Judge Thelma Hernandez versus Bryce Cox.
Okay. Let's take care of that one.
Calling docket number 2023 DCV 1694 Thelma Hernandez et al. Versus Bryce Cox et al.
May I have announcements, please?
Good morning, Your Honor. Russell Murray on behalf of plaintiff.
Good morning, Judge. Jim Darnell for Bryce Cox and his family.
Okay, and we are set. I guess we've reset the scheduling status conference. You all already have a trial date. Was there something that we needed to amend in terms of scheduling?
Yes, Judge. Mr. Darnell had asked for a different trial date. We have no objection, but we're informed by the court coordinator that we would have to come today for a hearing to change the current trial date.
What are we talking about?
I was hoping to move it back about 60 days, Your Honor. I just got into the case.
Okay, we can go to that May 16th trial date as well, if that's workable for you all. You have no issues with that. Let me ask, do we need to fully revamp the scheduling order, or can we just change that trial date?
Your Honor, I believe we had agreed on all the dates.
Mhm.
So I think we can just send it in, can't we, Russell?
Yes, I think all the other dates work, Your Honor, for us. It
Okay,
was just Mr. Darnell had a conflict with the actual trial setting. And
okay.
we're fine with keeping all the other dates.
All right, so if you all haven't submitted it yet, if you would just put the new trial date on there and then turn it in, we should be good to go, and we'll get, that should only mean in terms of, wow, in terms of your scheduling, that means that we don't have another setting until January 2025. That's fine by me. If there's anything, you need outside of those dates, file your motion, request a hearing, and we'll get you set.
We will, Judge. And just to confirm, we have your permission to cross out the date that's
Yes.
typed by
Yes.
the court.
Mhm.
And then Mr. Darnell will have your permission to sign on your behalf.
Absolutely.
Perfect. We'll submit that today, Judge.
Thank you so much. Y'all have a good day.
Thank you. You as well.
Thank you.
Okay. Who's next?
On page 2, Judge
Mhm.
Victor Reyes versus Leonela Cervantes. Mr.
Beal?
Beal.
Mhm.
Now calling docket 2020 DCV 4192 Victor Reyes versus Leonela Cervantes.
I have announcements, please.
Albert Veal here for Victor Reyes. Ready, Judge?
How are we doing, Mr. Beal?
Well, I'm doing okay. The case is doing not so well. We have a judgment in this case. We're trying to sell the house. I need an appraisal on the house.
Huh?
I asked the court for an order allowing the appraiser to enter the premises, and actually it's not Leonela anymore. It's her daughter won't let her into the house. So my idea is maybe do a show cause, invite her to court.
Okay. All
Okay.
right. Yeah, it looks like that order was signed back in March. We will go ahead and get you set for about 2 weeks out.
Okay,
get it set for about 2 weeks out, okay?
okay, and I'll file a motion for a show cause and we can have that hearing.
Okay, please file it. Thank you.
Thank you, Judge.
Have a good day.
Bye.
Who's next?
On the same page, Judge, just below that,
Okay, let's call it.
calling docket 2022 DCV 3342 Miriam Rivas et al. Versus El Paso County et al.
Good morning, Jonathan Baez on behalf of the plaintiff.
Good morning, Judge Kirk Paxton for the County of El Paso.
Okay, good morning. We're set for docket call, but I thought there was a request. There was an outstanding motion to compel. Is that right? That needed to be heard. Let me ask, this is the case, this is not the case. Well, yeah, it is. Judge Dominguez had requested from me a few weeks back if he could steal you all from my trial pool because you all were pretty much both involved in a separate case over there, and we're number one. Are we still in the same position? I had been agreeable to that simply because I had about 3 other cases that were specially set.
Kirk Paxton, Judge, I'm number one. I'm going next week. I already got the jury sheets in the 205th.
Okay.
It's not, but it's not with Miss Labonati's firm. She had a case in federal court that she's waiting for Judge Montalvo to let him know if they were going or not. But
okay.
But I'm definitely going, Judge.
I misunderstood that, Mr. Baeza. So, because I think you all had inquired with Mr. Hernandez on that. I understood you were both, and actually that's what I understood from Judge Dominguez, is that you were both over there. And it was kind of like, well, you can have them as long as they know that, I'm not going to cry a lot, but it probably will knock them down on my priority list. But in any event, okay, so everybody's busy. We have a motion to compel. I'll be candid with you all. I have not reviewed this motion, so let me pull it up.
I don't think that needs to be heard, does it, Kurt?
I don't believe so.
Okay.
You figured that out. I think all that's left is a pending plea to the jurisdiction.
Okay, and I do see an amended plea.
Yes, Judge.
And there was a response to that.
Okay, plaintiff's response to county's amended plea. Mr. Paxton, why don't you go ahead and get started?
Yes, Judge. Judge, this is a case against a school district, and we have waiver of governmental immunity for state political subdivisions, and it's most narrow for a school district. It can only be negligence arising out of the use or operation of a motor vehicle. And the issue, Judge, and it's not just this case, it's in so many cases I see, is they're trying to sue us for negligent selection, supervision, safety training, and all that kind of stuff. And that doesn't come within the ambit of the narrow waiver of governmental immunity. And so, Judge, when we talk about a plea to the jurisdiction, the district is not just immune from liability, it's immune from suit unless you come within the scope of the Texas Tort Claims Act. And so we've cited some cases. The waiver is for use or operation of a motor vehicle, and it also speaks about how if the employee would have been liable to the plaintiff as a private person. And so it's all about the person behind the wheel. It's not about the direct causes of action against the school district. Okay. And so we've started filing these because they want to do discovery like it's a truck case, like they're going after a commercial truck case with all the reptilian trial tactics and all that kind of stuff. And it's a square peg in a round hole here, Judge, because governmental immunity for a school district is use or operation of a motor vehicle if the driver would have been liable as a private person. And no more.
Thank you. Mr. Baeza?
Yes, Judge. So in regards to the negligent hiring, training, and supervision, in our response, we did non-suit that claim. So that point is moot. In regards to the negligent entrustment claim, we believe that's still a cognizable claim here, Judge. The plea to the jurisdiction as to that part of the claim only should be denied. The county negligently entrusted their vehicle to an employee. That's the negligent entrustment claim. The plea to the jurisdiction, the Texas Tort Claims Act waiver of immunity, allows or waives immunity from any cause of action arising from the operation or use. Now, while we agree to the negligent hiring, training, and supervision, negligent entrustment is specifically regarding a claim arising from the operation of use. They lent a vehicle to a negligent driver, and they should have known that. Part 2 of the plea to the jurisdiction is Mr. Paxson's request that the statutory caps of the Texas Tort Claims Act, essentially before trial even happens, that it be stated that only, or the jury be told that only $100,000 is available. Well, the statutory cap is not a basis for granting a plea to the jurisdiction. The simple point of that is it's premature. That is decided after the jury decides how much damage, if the plaintiff wins, how much the plaintiff wins, then and only then does the court apply the statutory grounds. And there's case law, Gulf Coast Center versus Curie, that's in plaintiff's response to the amended plea to the jurisdiction. Then and only then after does the court apply the statutory caps. It doesn't need to happen at this time. It doesn't need to happen before the jury trial. It doesn't need to happen. We don't need to tell the jury that. That's for the judge to do. And that's it, Judge.
Judge, for response, Judge,
Yes,
the negligent entrustment claim falls for 2 separate and independent reasons. First off, when you're talking about negligent entrustment, you are specifically focused on the entrustor. Was that entity or was that person negligent in giving the keys to a incompetent, unlicensed, reckless driver? Okay, it's focused on the entrustor. That doesn't fit within the language of the Texas Tort Claims Act waiver of governmental immunity. It just doesn't fit. It doesn't belong there. We look at use or operation if the driver would have been negligent as a private person. And that's the only waiver of governmental immunity here. But separately, and just as importantly, Judge, we've stipulated that the driver was in the course and scope of employment. So even if this wasn't a Tort Claims Act case, we'd still throw out the negligent entrustment under the admission rule. We've admitted vicarious liability. All negligent entrustment is a separate, independent theory of vicarious liability. To just introduce this evidence for no reason, it has no probative value whatsoever, Judge. If the driver is negligent, the county's, the school district's going to pay for that. And so we need to go no further than that. Actually, this is the County of El Paso case, isn't it? Rivas?
It is.
Okay. Judge, secondly, as far as the amount being sought, it's a matter of the court having jurisdiction over a claim. And I'm going to use the analogy. If I went to a JP court and I filed a claim for $100,000 or $250,000, they would kick it out. They say, we don't have jurisdiction to hear this. And they argue, well, we'll just apply that when we get to the judgment. No, I don't have jurisdiction to hear a claim for this amount. And similarly here, the court has jurisdiction only if allowed by the Texas Tort Claims Act. And the Tort Claims Act specifically states it can't be more than $100,000. And so that's the waiver of governmental immunity. That's the jurisdiction that would be conferred and nothing further. And so why ask for $500,000 if you can't get $500,000? I don't understand the argument on that either. But in any event, Judge, I think the plea to the jurisdiction should be sustained on all points.
Mr. Beza, anything else?
Yes, in regards to the negligent entrustment, the stipulation that the employee was driving for the county does not negate the negligent entrustment claim. It's a separate claim. Did you negligently entrust? Did you violate any reasonable standards in providing this vehicle to the employee? Admitting that he's employee does not take away that argument. There's some case law. It's my turn, Kurt. There's some case law in plaintiff's response. Plaintiff's response, the city of Gatesville versus True Love, and there's another one, Morin versus Moore, and citing a 8th Court of Appeals case wherein the courts have recognized a similar type of negligent entrustment principle when analyzing a personal injury or death claim when interpreting the use of tangible personal property. Well, A motor vehicle is tangible personal property. It is an item utilized, which is why it's waived, which is why the Tort Claims Act waives the immunity. That's first. So I would point the court to plaintiff's response and those cases therein. And in regards to the damages portion, well, specifically in the county's plea to the jurisdiction, it says it should be limited to $100,000. First of all, that's not incorrect, because it's $100,000 or $300,000 for each person, or $300,000 for each single occurrence. Here, there's two plaintiffs, so the $100,000 doesn't actually apply. It's the $300,000, and according to the plea to the jurisdiction, that's incorrect. So that's the first failure on their basis. The second is as I've already said, Gulf Coast Center versus Curry, Texas Supreme Court 2022 says that a trial court has the ability to render judgment after a favorable verdict, not immunity in the first place. This is something that the judge does after they apply the statutory caps. After the same happens in employment cases. I can ask for as much as I want, but if there's a cap in an employment case, the judge applies that cap afterwards. They don't tell the jury that, because that can affect what the jury does. Nothing further, Judge.
Judge, very quickly, a statutory cap is very different than jurisdiction. And I'm talking about subject matter jurisdiction. And so if the waiver of, and he's correct, it's $100,000 per person, so it'd be $200,000. And I guess I should have said per person in my plea to the jurisdiction, but that's what I intended. But again, Judge, there's just no jurisdiction to consider a claim in excess of $100,000 per person, $300,000 per accident. And Judge, he is absolutely wrong. I'll get you 40 years of citations that show that once you've stipulated that an employee is in the course and scope of employment, you cannot go further on the negligent entrustment claim, because it has no probative value. We've already said whatever, but if he was negligent, that's on us. That's pure vicarious liability. That's been stipulated all the way along. But what you can't do is say, well, I also want to introduce evidence of his bad driving record. No, you can't. That negligent entrustment can't go further after there's been a stipulation of vicarious liability. And Judge, I'll get you a string cite that goes back. That, as a young lawyer, as a baby lawyer handling auto cases, I knew that rule.
It's not in the plea, Judge. It's not in the motion. So if you can get the string of cites, that'd be great.
I'll get them.
All right. Okay. So anything else on the plea to the jurisdiction?
No, Judge.
Okay. So I'll have a response for you on that one today.
Thank you, Judge.
Let me, though, then kind of take this opportunity to go back and look now, since we will not be in trial here on this case. I still have to panel Friday morning, but we need to get it reset. Going forward, if we go forward, yeah, it's going to be really tough. This case in any other respect was good to go, right? You all, I think, announced ready. Okay.
Judge, it needs to be tried.
Yeah.
We went to mediation and we were nowhere close. We need a verdict on this one.
Let me look at some available dates, and maybe I'll just, if we get to that point, circulate informally with you all about y'all's availability, because I would like to get this reset quickly if we're going to reset, and that can be tricky, but I got to think there's a window or two in 2024 where I could carve out something for you all.
Judge, may I make a request to the court?
Yes, sir.
If you would tag this as a special setting under the local rules, I know
Yes.
Ms. Labinanti and Mr. Baeza, they're very busy. They're picking them up, putting them down, and we're busy too. And so that would really help me juggle the other courts so I can get to trial.
Yes, sir. We'll do that. Okay. Thank you for your time.
Thank you, Judge.
Have a good day.
I have another.
You have another. Okay. So this specially set. Who's next? Mr. Nanez.
You're muted.
Yes, you're muted.
I'm sorry, Judge, page 3, top of the page.
Mhm.
Deputy Marshal,
Okay, go ahead.
calling cause number 2022 DCV 3584, Deputy Marshal et al. Versus Brian Valdeviso et al.
May I have announcements, please?
Good morning, Paul Savinoff on behalf of the plaintiffs.
Your Honor, Renee Flores for the defendant.
Jeanette Garcia on behalf of defendant Lasso.
Except for a status conference, it looks like an ad litem was appointed back in January, and we've gone through a few status conferences. What's holding things up here?
There's a delay in getting TRICARE to respond to us on the lien. It's not a huge amount. It's only about $660. But we've requested the lien reductions. We've sent a follow-up emails to the claims rep, and we're just waiting for them to respond.
I mean, it sounds like, I think we were at that point in March, right, Mr. Savinoff?
Correct. There was also an Optum lien in the amount of roughly $2,000.
Mhm.
We sent a reduction request to Optum, and we're waiting for them to respond. And then recently, whenever I called to follow up on that status because we weren't hearing anything, I was informed that Optum actually kicked it back to the facility, and it's now being handled by a different company called MRS. So we've sent another reduction request to this new lien holder to get a response.
All right, one more 60-day reset. See you in 60 days.
May I be excused, Your Honor?
Yes, sir. Thank you,
Thank
Mr.
you,
See, Your Honor.
Have a good day.
Thank you, Judge.
Who's next?
In page, Judge,
Mhm.
calling docket 2022 DCV 2618, Tawana Danielle Pons versus Lancaster Hotel et al.
May I have announcements, please? I believe that's Landstar Hotels.
James Kennedy for the plaintiff.
Gabriel Canto for defendant Aluminum and Window Solutions.
Okay, we are set for a scheduling status conference. How are we doing on this case?
I think we had a hearing and the court wasn't available before. They were just asking what dates, and I was wanting a December trial setting. And the council was wanting something next year. I think there's a good chance we get the case resolved if we keep a December setting. So that's what I was asking for. So.
Okay.
Or try.
Okay. December is probably manageable, Mr. Kanto. Any reason we can't shoot for December?
Just directives from the client that they really don't want to try a case in December, but if that's the best we got, then yeah, I will.
So I don't see, just quickly looking here. We'll do December 13th.
That works for us, Your Honor.
Okay, so your DACA call will be December 11th. I'm just looking quickly. So we've never had a scheduling order here? No?
I don't recall.
We did have a scheduling order with a March date previously. I believe it was March, maybe it was May.
Ms. Hernandez, do you see a scheduling order in here?
I see the May 3rd jury trial, Judge, but let me.
Okay, well, if we had a jury trial set, I gotta think we had a scheduling order. So we'll get a new one, December date. Please return it with the new settings, and anything outside of those dates requiring a hearing, please request it via email.
Thank you, Your Honor.
Thank you. Have a good day.
Bye.
Who's next?
Last one, same page, Judge. Calling cause number 2022 DCV 2401 UT Company versus Aizen Salcedo.
May I have announcements, please?
Morning, Judge Hector Beltran on behalf of the plaintiff.
Good morning, Judge Christina McLaughlin on behalf of the defendant.
Final civil pretrial, and we got a June trial. How are we doing?
Your Honor, we're set for mediation, and I think the mediation deadline was yesterday or today, if I'm not mistaken, but because of the way securing mediations are right now in El Paso, it's taken us a while to get a date. We are scheduled for mediation, I believe, with Mitch Moss on June 3rd. Or hold on.
It's June 4th.
June 4th. I'm sorry, Judge. Yes, I just found it.
Perfect.
June 4th.
Perfect.
Our fingers are crossed. At least mine are. I hope yours are too, Christina.
Yes, Your Honor. This is only property damage. I don't anticipate us trying the case for property damage. So I'm convinced we're going to get it settled. It's a few days before trial.
Okay. So I'm going to look forward to receiving an email from Ms. Hernandez about 10 o'clock on the 5th of June that says things worked out. Otherwise, I'll see you on the 5th of June. But good luck.
Yes, it does. It does show. I'm looking at the calendar as well, Judge. I guess we have
It's
docket
outside
call
of
on the 5th of June.
Yeah, it's outside of the deadline, the mediation deadline, but kudos to you all for squeaking in under the wire of the docket call. So let's just see what happens, okay?
Okay, thank you, Judge.
Sounds good to me. Thank you, Judge.
Have a good one. Bye-bye.
Thank you. May I be excused?
Thank you. So that's everybody, Mr. Hernandez. We can get off of YouTube.
That's everything we had. We still have.
Wait, Mr. Baeza, who do you have?
I don't have that docket number, Mr. Baeza.
Who is it?
2024. Jasmine Silva versus Albino. Maybe it was canceled out.
Let's see. I forgot that you were there.
Final civil pre. Oh, it's because we filed in March a motion to continue. I guess it may have been granted. I just didn't see that.
Mr. Baeza, it's scheduled for the status and scheduling on June 26th.
Okay.
Thanks for hanging out.
Thank you. Thank you, Judge.
Bye.